One signature from Minnesota Governor Tim Walz just put thousands of gun owners on a collision course with new regulations, and most don't even know it happened yet. Today, I'm breaking down 7 dangerous executive orders and policy changes that could strip away your Second Amendment rights in Minnesota and spread to your state. By the end of this video, you'll know exactly what's coming, how to protect yourself, and why this matters even if you don't live in Minnesota. This is happening right now, and similar tactics are being tested in states across the country. Governor Walz couldn't get his gun control agenda through the legislature, so he's using executive power to bypass lawmakers and your voice. Here's everything you need to know. Number 1. Tim Walz just weaponized executive orders to push gun control without legislative approval. On December 16, 2025, Minnesota Governor Tim Walz signed 2 executive orders, Executive Order 25-12 and Executive Order 25-13, aimed at what his administration calls gun violence prevention. But here's what you need to understand. These aren't just policy suggestions. These are directives that force state agencies to take action against gun owners, and they were issued specifically because Walz couldn't get his own party to support his gun ban agenda through the proper legislative process. Under Minnesota law, executive orders carry the force of state action. That means state agencies, your Department of Public Safety, your Department of Commerce, your Department of Education, are now required to implement these anti-gun policies. We're talking about red flag law expansion, mandatory insurance data collection on firearms, and so-called safe storage education campaigns that lay the groundwork for future storage mandates. The legal consequence here is that once these agencies start collecting data and building infrastructure around gun control, it becomes exponentially easier to pass actual laws later. You're looking at the foundation being poured for a gun control regime that could include assault weapon bans, magazine capacity limits, and mandatory insurance requirements. So what do you do? First, understand that executive orders in Minnesota can be challenged in court if they exceed gubernatorial authority or violate constitutional rights. Contact Minnesota gun rights organizations like the Minnesota Gun Owners Caucus immediately and ask how you can support legal challenges. Second, document everything. If you're a Minnesota gun owner, start keeping records of any interactions with state agencies, any requests for information, and any changes to insurance policies that mention firearms. Third, get involved in the 2026 legislative session. These executive orders are designed to set up gun bans for next year's legislature. So you need to be contacting your state representatives and senators now, before session starts, to tell them you oppose any expansion of these executive actions into actual law. Don't wait until bills are filed. That's too late. But here's where it gets even more dangerous, and this affects gun owners nationwide. Number 2, Minnesota's red flag law is about to be supercharged with multi-language campaigns designed to increase confiscation orders. Minnesota already passed a red flag law in 2024, officially called an Extreme Risk Protection Order, or ERPO. This law allows courts to temporarily confiscate your firearms if someone convinces a judge you're a danger to yourself or others. Now, Executive Order 25-12 directs the Department of Public Safety to develop guidance and best practices for law enforcement, judges, and mental health professionals specifically to increase the use of these orders. Let me be crystal clear about what that means. The state government is actively training people to file more red flag petitions against you. Here's the scenario that should terrify you. You're a law-abiding gun owner in Minnesota. You get into a heated argument with a neighbor about politics. That neighbor, who now has access to multilingual educational materials in English, Spanish, Hmong, and Somali explaining exactly how to file an ERPO, goes to court and claims you're unstable. You get no advance warning. A judge hears only their side of the story in an ex parte hearing. That means you're not even in the room to defend yourself. The judge issues an order. Law enforcement shows up at your door, and you're required to immediately surrender every firearm you own. Under Minnesota Statute Section 624.7174, if you refuse to comply with an ERPO, you're looking at gross misdemeanor charges, up to 1 year in jail, and a $3,000 fine. If you lie about having firearms during the seizure, that's a felony. And here's the devastating part. Even after you eventually get a hearing and prove you're not dangerous, you've just spent thousands of dollars on legal fees, lost access to your firearms for weeks or months, and now you're in a government database as someone who had guns confiscated. The order also requires the DPS to start publishing ERPO data by county. Why does that matter? Because when the state starts tracking and publicizing how many red flag orders each county issues, it creates pressure on counties with lower numbers to catch up. It's a bureaucratic tactic to normalize and increase gun confiscations. You'll see headlines saying County X only issued 5 ERPOs this year, while County Y issued 50. Why isn't County X protecting public safety? That media pressure translates into more aggressive enforcement. Here's how you protect yourself. First, if you're in Minnesota, understand your state's ERPO law inside and out. Minnesota Statute Section 624.7171 through 624.7175 lay out the entire process. Know who can petition against you. Family members, household members, and law enforcement are the typical petitioners, but some states are expanding this. Second, if you're ever notified of an ERPO petition against you, hire an attorney immediately. Do not go to that hearing alone. The standard of proof for an ERPO is preponderance of the evidence, just 51% likelihood, which is incredibly low. You need professional legal help to fight it. Third, if you have contentious relationships with family members or neighbors who know you own firearms, document those relationships. Keep records of any threats they've made, any false statements, anything that could establish a pattern of harassment. If they file a frivolous ERPO, that documentation is your defense. Fourth, consider joining a legal defense organization that covers red flag law challenges. You need access to attorneys who specialize in this area. And this isn't just a Minnesota problem anymore. Number 3, the state government is now forcing insurance companies to spy on gun owners and report your firearms data. This is where Executive Order 25-12 gets truly invasive. The Minnesota Department of Commerce has been ordered to issue what's called a data call to every homeowner's insurance company licensed in Minnesota. What's a data call? It's a mandatory request for information that insurance companies cannot refuse. These companies must now submit detailed policy and claims data involving firearms to the state government. We're talking about the types of firearms you own, the value of those firearms, claims filed related to firearms, and detailed statistical breakdowns of gun-related incidents. Let me walk you through why this is so dangerous. You're a Minnesota homeowner, which means you're required by your mortgage lender to carry homeowner's insurance. That's standard across the country. Your insurance application asked if you own firearms, and many policies ask you to list high-value items, including guns for coverage purposes. You answered honestly because you wanted your firearms covered if they're stolen or damaged. Now that information, your name, address, policy number, and firearms details, is being handed over to the state government. By October 1st, 2026, the Department of Commerce will produce a full report to the governor summarizing all of this data and recommending changes to state law. What kind of changes? Here's what gun rights groups are warning about. Mandatory firearms liability insurance requirements, similar to auto insurance. Sounds reasonable at first, until you realize that insurance companies will price gun owners out of firearm ownership. If you're required to carry $1 million in liability coverage for owning an AR-15, and that coverage costs $2,000 per year, you've just created a de facto ban on firearms for anyone who can't afford it. That's not speculation. California and New Jersey lawmakers have already proposed exactly this type of legislation. The second possibility is that insurance companies, once they have this data, will start denying coverage or charging massive premiums to gun owners. Your homeowner's insurance could double or triple in cost simply because you own firearms. Third, this creates a firearms registry, something Second Amendment advocates have fought against for decades. Once the government has a database of every insured gun owner in the state, they know exactly who to target for future confiscation programs. The legal standard here is incredibly weak. This isn't a warrant or subpoena. It's an administrative data request, which means gun owners have almost no recourse to block it. The information will be collected, analyzed, and used to justify future gun control legislation. Under Minnesota law, insurance companies face regulatory penalties if they don't comply with Department of Commerce directives, so they have every incentive to hand over your data without question. Here's your action plan. First, review your homeowner's insurance policy immediately. Look for any questions about firearms. If your policy application asked about guns and you've already answered, that information may now be headed to the state. Contact your insurance company and ask specifically what data they're providing to the Department of Commerce under Executive Order 25-12. Get their answer in writing. Second, consider whether you want to continue listing firearms on your insurance policy. Some gun owners are choosing to insure valuable firearms through specialized policies from companies that don't operate under state homeowners insurance regulations. These may not be subject to the data call. Third, contact your state representatives and demand they introduce legislation blocking this data collection. Minnesota's legislature could pass a law prohibiting the Department of Commerce from collecting firearms data from insurance companies, but they'll only do that if constituents are screaming about it. Fourth, document everything. If your insurance rates suddenly increase after this executive order, if your coverage is canceled, if you're denied a policy because you own firearms, document it and report it to gun rights organizations. That creates evidence for potential class action lawsuits. But the data collection doesn't stop there. Number 4, Minnesota is launching a statewide indoctrination campaign disguised as safe storage education, and your tax dollars are paying for it. Executive Order 25-12 contains a directive that should make every gun owner's blood boil. The Department of Public Safety and the Minnesota Department of Education are now instructed to produce and distribute materials on firearms storage. These materials include best practices for storing guns, where to get locks and safes including low-cost and free options, and informational notices that will be distributed to schools and parents. The order specifically requires translation into English, Spanish, Hmong, and Somali. Now here's what they won't tell you. This executive order begins by stating that firearms are the leading cause of death for children and young adults in America. That's a blatant lie. It's a statistic that anti-gun groups manufactured by manipulating data. They include 18 and 19-year-olds, legal adults, in the definition of children. They include gang violence deaths, which are overwhelmingly young adults involved in criminal activity, and they cherry-picked years to exclude vehicle deaths and medical causes. The actual leading cause of death for children in America is accidents, car crashes, drowning, poisoning, by a massive margin. But this executive order enshrines that false statistic as state policy and uses it to justify a propaganda campaign in schools. Here's the scenario you need to worry about. Your child comes home from school with a flyer about gun safety. Sounds great, right? Except that flyer is telling your kid that guns in the home are a death sentence, that your firearms are statistically more likely to kill them than protect your family, and that they should tell a teacher if they feel unsafe because of guns at home. That last part is critical. Schools are increasingly treating gun ownership as a child welfare issue. We've seen cases across the country where children are questioned by school officials or even child protective services because they mentioned that their parents own firearms. This education campaign creates a pathway for schools to report gun-owning families to authorities. The order doesn't mandate that you store your firearms in any particular way yet, but it uses state resources to promote a specific storage narrative, and that narrative always leads to mandates. In Massachusetts, you're required by law to store firearms in a locked container or with a trigger lock when not under your direct control. Violation is a felony with up to 2.5 years in prison. In California, if you don't store firearms in a Department of Justice-approved manner and someone gains unauthorized access, you face criminal liability even if no one is hurt, up to 6 months in jail and a $1,000 fine. This education campaign is laying the groundwork for Minnesota to follow the same path. Here's what's really insidious. The order specifically directs distribution of information on low-cost and free options for locks and safes. That sounds helpful until you realize it's conditioning the public to accept the idea that safe storage is the government's business. Once citizens are used to the state providing free gun locks and telling them how to store firearms, the next step is making those recommendations mandatory. It's the classic regulatory playbook: educate, incentivize, mandate. Here's how you fight back. First, if you're a Minnesota parent, watch for any materials coming home from your child's school about firearms. Read them carefully. If they contain false statistics or anti-gun propaganda, document it and file a complaint with the school board. Demand equal time for actual firearms safety education like Eddie Eagle or NRA programs that teach children what to do if they find a gun. Stop, don't touch, leave the area, tell an adult, without the anti-gun messaging. Second, talk to your children directly about firearms. Kids who grow up in households where firearms are demystified, where they receive proper training and education, are far less likely to have accidents. Don't let the state control that conversation. Third, refuse to participate in any free gun lock programs or government-sponsored storage initiatives. These programs create records of gun owners and condition citizens to accept government intrusion. Buy your own storage solutions from private companies. Fourth, attend school board meetings and demand transparency about what materials are being distributed to students regarding firearms. Make it clear that you will not tolerate anti-gun indoctrination in public schools funded by your tax dollars. And speaking of children, there's another angle you need to understand. Number 5. Governor Walz just created a hand-picked council to develop gun control recommendations, and Second Amendment advocates were deliberately excluded. Executive Order 25-13 establishes what the governor is calling a statewide safety council. Sounds neutral, right? Here's what it actually is: a panel of anti-gun activists, government bureaucrats, and sympathetic experts who will spend the next year developing policy recommendations for the 2026 Minnesota legislature. And here's the key detail that should alarm you. The executive order does not require, or even mention, including any Second Amendment advocates or gun owner representatives on this council. This is stacking the deck. Plain and simple. You're looking at a government-funded commission that will produce official reports and recommendations calling for assault weapon bans, magazine capacity limits, ammunition restrictions, mandatory waiting periods, may issue permit systems, and every other gun control scheme in the anti-gun playbook. And because this council has the official imprimatur of the governor's office, legislators will treat its recommendations as credible and evidence-based, even though the entire process is rigged from the start. Here's how this plays out in practice. The statewide safety council holds hearings, probably in liberal strongholds like Minneapolis and St. Paul. They invite testimony from anti-gun groups like Everytown for Gun Safety, Moms Demand Action, and law enforcement officials who support gun control. Gun owners who show up to testify are given limited time. Their testimony is dismissed as emotional or unsupported, and the final report barely mentions their concerns. Then, in January 2026, the council releases a 200-page report full of cherry-picked statistics, misleading studies, and doomsday predictions about gun violence. That report becomes the blueprint for every gun control bill filed in the Minnesota legislature next session. This is exactly what happened in Oregon before they passed their magazine ban. The state created a firearms safety work group that produced recommendations leading to Measure 114, which banned magazines over 10 rounds and created a permit-to-purchase system so burdensome that it effectively shut down gun sales in the state for months. In Washington, a similar violence reduction task force led to the passage of semi-automatic rifle restrictions and waiting periods. These councils are a proven strategy for bypassing genuine public input and manufacturing consent for gun control. The legal angle here is that these councils operate in a gray area of administrative law. They're not legislatures, so they don't have to follow the same transparency and representation requirements. They can exclude voices they don't want to hear, selectively gather evidence, and produce recommendations that never would have survived genuine public scrutiny. And because they're advisory bodies, not regulatory agencies, they're often exempt from Administrative Procedure Act requirements that would normally allow public comment and challenge. Here's your battle plan. First, demand that the Minnesota legislature refuse to consider any recommendations from the statewide safety council unless it includes equal representation from Second Amendment groups. Contact your representatives now, before this council even convenes, and make it clear that you will not accept a rigged process. Second, monitor every public hearing or meeting this council holds. Show up in person if possible. If you can't attend, submit written testimony. Flood them with pro-Second Amendment voices so they can't claim there was no opposition. Third, start organizing now for the 2026 legislative session. Gun rights groups need to be prepared to testify against every bill that comes out of this council's recommendations. That means having experts, attorneys, and citizen advocates ready to counter the council's narrative. Fourth, go directly to the media. Don't let the council's report be the only story. Write op-eds, call into radio shows, use social media to expose the fact that this council was designed to produce predetermined anti-gun conclusions. Make the bias obvious to everyone. But there's an even bigger picture you need to see. Number 6. What's happening in Minnesota is a beta test for gun control strategies that will be deployed in your state next. Here's what most gun owners don't understand. State-level gun control doesn't stay isolated. Anti-gun groups coordinate nationally. When a strategy works in one state, it's immediately copied in others. Minnesota's executive order approach is particularly dangerous because it doesn't require legislative buy-in. That means governors in blue states, and even purple states where legislatures are split, can bypass elected representatives and implement gun control through executive fiat. Think about your state. Does your governor support gun control? Do you have a state department of public safety that could be directed to expand red flag law enforcement? Do you have homeowners insurance companies that could be forced to report firearms data? If the answer to any of those questions is yes, then what's happening in Minnesota is coming for you. We've already seen this pattern with red flag laws themselves. Connecticut passed the first one in 1999, and now 21 states plus the District of Columbia have them. Magazine capacity bans started in California and have spread to 10 states. Assault weapon bans began in California and Massachusetts and are now in 9 states. Executive orders directing state agencies to collect firearms data and promote gun control narratives are the next domino to fall. Let me give you the specific mechanism by which this spreads. Everytown for Gun Safety and similar organizations draft model legislation and model executive orders. They provide these templates to sympathetic governors and legislators across the country, along with polling data, talking points, and even funding for campaigns. When Tim Walz signed Executive Orders 25-12 and 25-13, he didn't write them himself. His staff used templates that have been circulated nationally. You can bet that governors in states like Michigan, Wisconsin, Pennsylvania, New York, New Jersey, Illinois, Colorado, New Mexico, and Nevada are looking at Minnesota's example right now and asking their legal teams, can we do this here? The danger escalates when you consider federal implications. If enough states adopt firearms insurance data collection requirements, gun control advocates will push for a federal system. They'll argue that interstate commerce in firearms requires federal oversight of insurance, and suddenly you're looking at a national gun owner registry administered by the Department of Commerce or a new federal agency. If enough states expand red flag law enforcement through executive action, Congress will point to that success as justification for a federal red flag law. We've already seen this playbook with marijuana. State-level decriminalization led to federal policy changes. The same thing can happen with gun control, except in reverse. State-level restrictions leading to federal restrictions. Here's what you absolutely must understand. The Second Amendment is under coordinated, sophisticated attack. This isn't random. It's not isolated. It's a deliberate strategy to chip away at gun rights through bureaucratic action, data collection, and normalization of control measures, all while avoiding the backlash that comes from trying to pass blatant gun bans through legislatures. And it's working. Gun owners are being boiled like the proverbial frog. The water temperature keeps rising, but we don't jump out because each individual change seems small and manageable. By the time we realize we're in danger, we're cooked. Here's how you stop this national threat. First, support gun rights organizations that operate at the national level. NRA, Gun Owners of America, Firearms Policy Coalition, Second Amendment Foundation. These groups track state-level actions and coordinate legal challenges across multiple states. When Minnesota's executive orders get challenged in court, the precedent set there will affect what governors can do in your state. Second, make Second Amendment issues a non-negotiable voting priority. Don't just vote based on national elections. Your state governor, your state legislators, your local sheriff all have direct impact on whether these executive order tactics succeed or fail. Research every candidate's position on gun rights before you vote. Third, cross-state coordination matters. If you're in a pro-gun state, don't think you're safe because your state has strong Second Amendment protections. Support gun owners in states under attack. Donate to legal defense funds for Minnesota gun owners. Pressure your federal representatives to introduce legislation blocking states from creating firearms registries through insurance data collection. What happens in Minnesota this year determines what battles you'll fight in your state next year. And the timeline for this fight is tighter than you think. Number 7. these executive orders are just the opening move. The real assault on Minnesota gun rights begins in January 2026. Governor Walz has made no secret of his intentions. The executive orders explicitly state that they're designed to lay a foundation for future gun violence prevention legislation and create policy recommendations for the 2026 legislative session. Translation: everything we've discussed, the red flag expansion, the insurance surveillance, the safe storage propaganda, the stacked safety council, is setting the stage for actual laws that will strip away your Second Amendment rights. Here's what's coming to Minnesota in 2026, based on the governor's own statements and the pattern in other anti-gun states. First, an assault weapon ban. Walz has repeatedly called for banning so-called assault weapons and high-capacity magazines. Expect legislation that bans semi-automatic rifles with detachable magazines and any combination of features like pistol grips, adjustable stocks, or barrel shrouds. California's AWB list includes over 70 specific firearm models and bans any semi-automatic rifle that accepts detachable magazines and has one prohibited feature. New York's SAFE Act includes similar provisions. Minnesota's version will likely mirror these laws. If passed, you'd be looking at a Class C felony for possessing a prohibited firearm, up to 5 years in prison, and a $10,000 fine under Minnesota Statute Section 609.11. Second, magazine capacity limits. The likely target is 10 rounds, which is the standard in California, New York, New Jersey, Massachusetts, Connecticut, Maryland, Colorado, and Washington. Any magazine that holds more than 10 rounds would be illegal to possess, manufacture, sell, or transfer. Violation typically carries gross misdemeanor or felony charges. Colorado's law imposes up to 18 months in prison for possession of a prohibited magazine. These laws don't just ban future sales, they require you to dispose of or permanently modify magazines you already own. That's ex post facto criminalization of lawful property. Third, mandatory firearms liability insurance. Using the data collected from insurance companies under Executive Order 25-12, legislators will argue that uninsured gun owners are a public menace and must carry liability coverage. San Jose, California already requires gun owners to pay an annual fee and carry liability insurance or face fines up to $1,000 and confiscation of firearms. A statewide Minnesota version would make firearm ownership financially impossible for many citizens. And here's the trick. Insurance companies will either refuse to offer the required coverage or price it so high that only wealthy individuals can afford it. That's a Second Amendment right available only to the rich. Fourth, safe storage mandates. All that education about proper storage becomes a criminal requirement. You'll be legally required to store firearms in a locked container or with a trigger lock whenever they're not under your immediate control. If someone accesses your firearm and you didn't comply with the storage law, you face criminal charges, even if the person who accessed it was a burglar who broke into your home. Massachusetts law requires locked storage and imposes felony charges for violations. Enforcement is the real nightmare. These laws often get applied after the fact. Your home gets broken into, guns are stolen, and you get charged with a crime for not storing them properly. Fifth, extreme risk protection order expansion. The executive orders focus on increasing ERPO awareness, and filing is just the warm-up. Expect legislation that expands who can petition for an ERPO, possibly including teachers, employers, co-workers, and even healthcare providers. California allows employers and educators to file red flag petitions. Some states are considering allowing anyone to file anonymously. You could be disarmed based on a petition from someone you've never met. The timeline is critical. Minnesota's legislative session typically runs from January through May. Bills will be introduced in January 2026. Committee hearings will happen in February and March, floor votes in April, and the governor's signature in May. That means gun owners have a very narrow window to organize, testify, and apply pressure. If you wait until bills are filed, you're already behind. The time to act is now, December 2025 and early 2026, before the legislative machinery starts moving. Here's your complete action plan for the next 6 months. First, join every Minnesota gun rights organization immediately. Minnesota Gun Owners Caucus, Gun Owners of America Minnesota, NRA Minnesota. These groups coordinate testimony, lobby legislators, and organize grassroots campaigns. You need to be plugged into their alert systems so you know the moment bills are filed. Second, identify your state senator and representative right now. Find their contact information, their committee assignments, and their voting records on gun issues. Call their offices weekly starting in January. Show up at their district meetings. Make yourself a known constituent who will hold them accountable. Third, prepare to testify. Minnesota allows public testimony on bills during committee hearings. You need to be ready to take time off work, drive to St. Paul, and testify in person about how these laws will harm you. Written testimony is better than nothing, but in-person testimony has far more impact. Fourth, recruit 5 other gun owners to do the same thing. This fight cannot be won by a small group of activists. It requires mass mobilization. Every gun owner you know needs to be contacting legislators, attending hearings, and voting in the next election. Fifth, vote in 2026. Minnesota has state elections in November 2026. Every single seat in the Minnesota House and half the Senate seats are up for election. Pro-gun candidates need to win, and anti-gun incumbents need to be voted out. That's the only way to permanently stop this threat. But don't make the mistake of thinking this is just about Minnesota. Let's recap the 7 threats that Minnesota's executive orders have unleashed on gun owners. Number 1. Executive order power grab. Walz bypassed the legislature to implement gun control through state agencies without your vote. Number 2. Red flag law expansion. Multi-language campaigns to increase ERPO filings and gun confiscations against law-abiding owners. Number 3. Insurance surveillance system. Mandatory reporting of firearms data by insurance companies, creating a de facto gun registry. Number 4. Safe storage propaganda. Taxpayer-funded indoctrination in schools laying groundwork for mandatory storage laws. Number 5. Stacked Safety Council. Hand-picked anti-gun panel developing recommendations with zero Second Amendment representation. Number 6. National threat. Minnesota is the beta test for executive order gun control spreading to other states. Number 7. 2026 legislative blitz. Assault weapon bans, magazine limits, insurance mandates, and more hitting the legislature in January. Any one of these threats could cost you your Second Amendment rights, your firearms, or your freedom. Don't let confusion about gun laws put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex gun laws every week so you can defend your rights with confidence. Next video, I'm covering the latest federal gun control bills being fast-tracked through Congress that could override your state's protections. You won't want to miss it. Share this video with every gun owner you know. This is your modern-day tavern for Second Amendment information. Stay informed, stay prepared, stay armed, and stay free.